So, good afternoon. This is one of our short EJIL live sessions, and with me is Professor Dapo Akande of Oxford University, but also of the editorial board of the European Journal of International Law, and most importantly, the founder of our wonderfully successful EJIL Talk blog of the European Journal of International Law. But today you're with me, Dapo, as a scholar, and the issue we want to talk about is the relationship between international humanitarian law and human rights law. And very often when I've attended conferences dealing with international humanitarian law, you hear from the soldiers, so to speak, the Americans, the British, the Israelis, the French, the people who actually have to apply international humanitarian law, that it's a category mistake to confuse international humanitarian law with human rights law. They derive from different sources, they have a different ethos, they have a different telos, and that it's simply inappropriate from their point of view to overlap the two.
Yeah, I think you're certainly right that military lawyers and soldiers have this instinctive reaction, and in some ways they are right in the sense that the history, the origins of the two disciplines are different. But in one way, I think they're wrong. I mean, they're wrong in the sense that both disciplines have the idea of humanizing the way that states behave. The question that arises is whether we can use the same tools that we use in time of peace, in times of war. And my reaction to that is that it all depends on whether one thinks that human rights law must mean the same thing at all times. So when they have this instinctive reaction, what they're thinking about is the way in which human rights law applies in ordinary times. They say we can't apply this in war because war is different, but that presupposes that we are reaching exactly the same results in peacetime as we're reaching in wartime, which I don't think is the case.
But they might turn back to you and say, sure, if there was an understanding, and I'm just playing the devil's advocate, if there was that kind of understanding in the interpretative community of human rights law, that you can apply human rights in times of war or to combatants, but it might not necessarily be in quite the same way, the proportionality test might be different, everything would be hunky-dory. But I think part of their complaint is, for example, in relation to forays of, say, the European Court on Human Rights, that they are so accustomed to see human rights law in the normal context of liberal democracies in times of peace, that they don't quite make the distinction that you insist should be made. Is there anything to that argument?
So there is something to that, and I think there are two things here. So first of all, the question is who is doing the interpreting? So one of the features of international humanitarian law, as with most areas of international law, is that there is no authoritative interpreter. And to some extent, the community of people who work in international humanitarian law are used to that. They're used to being, and usually we're talking about state agents, are used to a sort of auto-interpretation. Whereas, of course, in human rights law, there's a different tradition. We have courts, we have quasi-judicial bodies, we have special rapporteurs, we have people who have an authority to interpret. So I think that's the first discomfort, that there's somebody else out there who's interpreting this. And then the second one, which arises from what you've just said, is that these interpreters are used to doing it in a different context. But there, I think that what we are seeing is that although it is true that human rights bodies are used to applying it, in this liberal tradition that applying human rights law in this liberal tradition that you've just described, the more that they also encounter the problems that arise in time of armed conflict, the more that they tend to reach a degree of accommodation. So we're seeing that with the European Court of Human Rights now, where, for example, to take one decision, which I think was quite stunning, last year in the Hassan case that dealt with detention, the European Court said that the prohibition of deprivation of liberty is to be interpreted in the light of the Geneva Conventions. Now, on its face, that doesn't sound so amazing. I think most human rights courts would reach the same conclusion. But the reason that that was so astounding was because when you look at the text of the European Convention on Human Rights, Article 5, it has prohibition of deprivation of liberty, except in certain specified circumstances. So only, it appears to say, these circumstances. And security detention in time of armed conflict is not one of them. But the court read it in. And I suspect the reason the court read it in is because they have now, over the years, repeatedly been faced with questions of applying these principles in time of armed conflict, and it shapes their own understandings as well.
So, now to come at it from the exact opposite view, sometimes you read criticisms of the various international criminal tribunals that we have, that they don't pay sufficient attention to human rights law. That they are working within the universe of international humanitarian law, and that they might do with a good dosage of human rights law as a sort of second layer or first layer in their understanding of international humanitarian law. Do you think there's anything to that critique?
I think there is. I think there is. So in these communities of human rights law, humanitarian law, there have been all these debates about which of these bodies of law is the lex specialis, and people tend to plump for one as opposed to the other. So, there are those who say, yes, it's humanitarian law, that's lex specialis, it's specifically designed for armed conflict, and then people on the other side say, yes, but we have these human rights principles, if states haven't derogated from them. The way that I sort of look at it is, both on technical grounds of international law, but also in more normative grounds, is that first of all, what we're seeking is what I describe as sort of coordinated interpretation of these areas, and we can see that principle playing out in the Vienna Convention. However, this has its limits. So there are circumstances where we can use one body of law to interpret the other, and it can be human rights law that's used to interpret humanitarian law, or it could be the other way around. Humanitarian law that's used to interpret human rights law. But this has its limits. There are times when we just have to hold our hands up and say, we're beyond interpretation. And that what has happened is that states have really entered into conflicting obligations here, and that one does not remove the other.
So there we're back to the classical fragmentation of international law set of issues.
Exactly. So there we're back to classical fragmentation of international law issues, except that in this particular area, relationship between human rights and humanitarian law, there is actually a tool which we tend to ignore for dealing with it. So in this particular area, that tool is the tool of derogations. But for one reason or another, both states and scholars have tended to, and courts for that matter, have tended to ignore this tool. And I actually think that we should go back to looking at this tool of saying, look, there's a conflict here. The way of dealing with that conflict is to hold our hands up to say, in this particular circumstance, we cannot abide by these types of, by this category of obligations. And so states need to take essentially a hard look at themselves and say, in advance, we derogate from these obligations. It's politically difficult, but I think it's the honest thing to do.
Final question. Both of us are professors. We spend our lives giving grades. Would you be willing to grade the ECHR and grade the international criminal tribunals in how they deal with this kind of balancing international humanitarian law and human rights law? ECHR, A minus, B plus, B.
If I'm going to be delicate, all I will say is certainly not an A.
Certainly not an A.
Yes.
Ladies and gentlemen, thank you very much. Thank you, Dapo.
Thank you. It's been a pleasure.